Mr. Perry, I had asked the question about 4 weeks ago regarding an opinion on whether leave with pay for union negotiator violates the Labor Management Relations Ordinance, and you were supposed to get back with me on that issue. And this was the opinion by Bruce Thompson, our city attorney. I've not received a response back on that.
Mr. President, Councilor Sanchez, we have a formal response back from the city attorney's office, and the short version of that response is that there are two particular ordinances on point. One, of course, is the charter provision, I should say, and the other one, the merit system ordinance. Clearly, it seems to be within the discretion of the merit system ordinance that that members of labor unions could be paid to negotiate for on behalf of their own members. That would be, I think it's important to point this out, that would be the city paying labor negotiators and staff to negotiate for labor. At the same time, the city pays management staff to negotiate on behalf of the city. The charter prohibits that. It specifically states that, under the Labor Management Relations Ordinance, that labor's negotiators are not to be paid, they're to be unpaid. However, under the Merit System Ordinance, it says that it's within the discretion, that they can be paid. It doesn't say shall be paid or otherwise. And I don't think it's particularly ambiguous. There's those two ordinances, and at the end of the day, I think it's the administration's call on, from a policy perspective, of whether union members should be paid out of taxpayers' money to negotiate contracts on their own behalf. And that's a policy prerogative that council, as well as the executive branch, the mayor, have got to, basically have their input in.
And based on our city attorney, who's not here this evening, and I'm sure you've read his opinion also, and based on his conclusion, it says the assertion that the LMRO precludes the city from providing the IAFF's negotiating team with time off with pay is without support. There is also support for a contrary conclusion. On balance, it appears that the stronger argument is that the city is not precluded from providing leave with pay to union negotiators.
And that's an interesting legal memorandum from Mr. Thompson, and I think it's important to clarify one point. When you say that Mr. Thompson's legal memorandum states that the city's position that the city is prohibited under the Labor Management Relations Ordinance is without support, he says that it is not without support, meaning that, in fact, there is support because the plain reading of it says labor is not to be paid for negotiations and through the process. And that's in the specific ordinance of the Labor Management Relations Act. But then when you look at the Merit Protection Act, it says that they can be paid. And so we take the position that we agree with Mr. Thompson clearly, that one ordinance says that they shouldn't be paid, the other ordinance says that they can be paid, and at the end of the day, the administration has to make take a position. We don't think it's an unreasonable policy position to expect labor unions who collect dues and pay their folks to basically pick up the compensation of their labor negotiators and not the taxpayers. Now, some people could differ with that, there's no doubt. But I think it's laid out fairly clearly in those two ordinances that one says you shouldn't, one says you can. And that's really...
So we've got two different laws in place. So if we don't pay them, then we're violating our own ordinance. Is that correct?
No, actually, that's interesting if we looked at it that way, Mr. President, Councilor Sanchez. One ordinance says you can't pay them. One says you can pay them. Now, if we went ahead and pay them, we would be violating the Labor Management Relations Act that says they shouldn't be paid. But we wouldn't be violating the Merit System Ordinance that says they can be paid. And if we went the other way, basically, and didn't pay them, then we'd be violating.
But in the past, they have been paid. Is that correct?
From my understanding, there was a period in time when they were paid. I don't know what happened last year.
Okay, thank you.
Yes, sir.
And let's see, Councilor Garduno also, as a co-author of this ordinance, but or the memorandum. I think I have one question for the CAO. Okay, we're going to go next to Councilor O'Malley, then I have another follow-up, but I'll come back to that.
Thank you. On this, clearly we have a conflict here. I think and I want to make this very clear, what we are violating is their contract. Their contract does state that that they can be paid, and so, you know, this is my concern, is that we are not negotiating, I think, fairly. We got the proposal from the mayor for the budget, and in it states that he wants to set aside a certain percentage for possible reinstatement. It's not really a raise, but reinstatement of salary that was cut following labor negotiations. We go through this process of labor negotiations, come out with a contract of which we ratify, which is law. That's the law. And now, basically, because this administration doesn't want to do it, is now trying to find excuses not to do it. We were able to go into those contracts and change some things for economic reasons, and we were able to change the pay. But we don't have any right to go in there and start messing up with any other language. That is part of the collective bargaining process. We are up for renegotiation with some of these contracts. That's when this needs to take place. Otherwise, we're violating contracts that exist. That's the way I read it. Of course, I'm not an attorney, but that's the way I read it. And I don't think that's playing fair. If this administration has an issue with a contract that exists, you're going to go up to renegotiate. Change it if you don't like it. All right? And then, you know, if this council wants to ratify it, that's their business. But it just isn't fair to go back and start changing the game because you don't like it. By the way, you know, we're always keep saying, oh, the taxpayers paying for this tax. Taxpayers are paying for your salary. They're paying for all the salaries and all the salaries of employees, whether it be from the very top to the folks at the bottom. So, you know, let's just stop talking about that because I don't think that's a fair statement to continue to make. But I really feel like what we are is in violation of the contracts that exist currently.
Thank you, Councilor O'Malley. You want to respond?
Just briefly, Mr. President, Councilor McNally, there's also severability provisions in each contract that says that if any provision is illegal, that it's stricken. And there's other provisions in there that have dealt with the issues from multi-year agreements that were in fact invalidated by the court as being either unconstitutional or otherwise illegally invalid. That is the continuing of an extension that's in litigation thus far. We certainly want to play by the rules, Mr. President, Councilor O'Malley, and stick to the provisions of the contract. But we think also at the same time we have to protect the interests of the taxpayers. And I don't mean to overuse that term, and with all due respect, I apologize for any sort of misinterpretation the Councilor may see with that. But I think it is important to do that. And if we have provisions that were in those contracts that we think are invalid, we have an obligation to basically, you know, assert some positive direction in trying to correct those. Thank you, Mr. President.
Well, I just want to say that you just said yourself that you have two conflicting things. It's not that they're invalid. I think you said so yourself, that it's not illegal, that it's a policy issue. And, you know, let's not continue this conversation. But, you know, I think we're going to end up with a lot of legal fees as a result of this, and for what? That's what I say.
Thank you, Councilor. And perhaps we should have some clarifying amendments of those two ordinances so that they tie in the future, so that we don't have this problem coming up. Councilor Benton, followed by Councilor Garduño.
I don't know if we have anyone from air quality here tonight, but this is a question that I suppose could be, you could try to field it, Mr. Perry, and if not, we could get back with an answer at the next meeting. But as everyone knows, we had terrible dust conditions yesterday, and I had a call from a constituent asking what we're doing in terms of enforcement of the dust control requirements of the city. Knowing that it's a Sunday, I don't know whether we had anybody working then, but and